Thank you all for joining us this evening for our third professorial lecture in the series to honour and celebrate the outstanding achievements of our esteemed academics at the College of Asia and the Pacific. I'm Helen Sullivan, Professor and Dean of the College. I'm very lucky to be so. Before we begin, I'd like to acknowledge and celebrate the traditional owners of the lands on which we're meeting, the lands of the Ngunnawal and Ngambri people of the Canberra region, and to pay my respects to elders past and present and to all First Nations people who are with us this evening. Tonight, we gather and celebrate and recognise Professor Anthony Regan's contributions to research and teaching at the college. But before I get on to introducing Anthony, we have two rather special and indeed unexpected guests with us this evening who have made a long and not altogether straightforward journey from Bougainville, currently part of Papua New Guinea, for the express purpose of attending this lecture. One of these guests is Mr. Ezekiel Massa, who is a lawyer. We appear to have a lot of lawyers with us this evening. And Mr. Massa is not only the Attorney General for the autonomous Bougainville government, but also holds another unusual ministry in that government. He is the Minister for Bougainville's Independence Mission Implementation. That ministry was established soon after the November 2019 referendum on Bougainville's independence, in which 97.3% of those registered Bougainville voters chose independence over the alternative option of greater autonomy. I understand that Mr. Massat has chosen at very short notice to attend this lecture because of his interest in, and indeed his own extensive experience of, conflict resolution and constitution making as a result of conflict resolution. So it's a great pleasure and an honour to have Mr. Massat with us. The second guest is another Bougainvillean lawyer, Mr. Kenneth Nanai. He's the Secretary for the Autonomous Bougainville Government Department of Police and Justice, a role he's held for 7 or 8 years. And he is also, along with Mr. Massat, involved in establishing the Autonomous Bougainville Government's 2022 actions, establishing the Bougainville Constitutional Planning Commission. And for those of you who don't know, that's the body that will be having responsibility to develop a new constitution for Bougainville, required to give effect to whatever ultimate decision is made by the ongoing joint PNG Bougainville post-referendum decision-making process, which began soon after the referendum. And through that process, Bougainville is seeking PNG recognition of its independence by no later than 2027. So what we see here is not just two incredibly welcome guests, but also the reality and the importance of the work that happens here in the College of Asia and the Pacific. Post-conflict constitution making is clearly not just a topic of theoretical interest, but like everything that we do here at the college is something that both has real and practical application, and it's an example of where we learn by doing as well as by thinking. So we welcome both of our esteemed colleagues here, and we also welcome the interest that they've shown in the work of the college, and indeed, in particular, the work of the person we are here to celebrate tonight, Professor Regan. Now, Anthony is a constitutional lawyer who has lived and worked in Papua New Guinea for 17 years, where he was a lawyer for various government bodies and taught at the University of Papua New Guinea. He's also undertaken constitutional advising work in a variety of countries, but is probably most well known for being a long-term advisor to the Bougainville parties during the Bougainville peace process. And in 2002 to 2004, he was an advisor to the Constitutional Commission and Constituent Assembly that developed the Constitution of the Autonomous Region of Bougainville. Anthony's diverse research interests include constitution-making processes, constitutional design in conflict resolution, and conflict analysis and resolution, especially in conflicts involving identity, resources, and self-determination issues. It's been an interesting feature of these lecture series. This is the third, as I said, in the series, where the colleagues who are not traditionally known for wearing suits have shocked us all by turning up to deliver a professorial lecture wearing a suit. It is with some relief, but I also admit no great surprise that I recognise that Professor Regan has chosen to back the trend and appears to us very much as he appears to us every day. So with that, it is with great pleasure that we welcome Professor Anthony Regan to this lecture.
Thank you, Helen, and thank you, colleagues and friends, both colleagues and friends, for coming. It's a great honour to have you all here. Thank you especially to my friends and colleagues, Ezekiel Massat and Kenneth Nane, for coming. It's an amazing honour to have them willing to do that. As for the suit, I don't own one. The last time I wore a suit was when I worked for the Uganda Constitutional Commission from 1991 to 1994, and East Africa is very formal in bodies like a Constitutional Commission. So even the later Chief Justice, who was the head of it, wore his suit to the toilet, and we'd welcome him when we met him as Your Lordship. So it's terrible what a suit can do to you. It's a bit daunting being asked to do a professorial lecture. I'm a very late career professor, and I must admit, when I applied for promotion, I never thought that there'd be such a thing. I don't think there wasn't a series in existence at that time. And I know at least one colleague who's here today who's indicated to me that he's thinking of withdrawing his application for promotion because of the prospect of having to do one of these. We'll see whether that really happens. I should say that I want to make a couple of quick introductory points. That I've been working in this sort of field for 42 years, since 1981, when as a young 28-year-old lawyer who'd been working in Adelaide for 5 years, basically as a barrister, and was specialising more and more on wrongful dismissal cases. I learned a lot being a barrister, including about the importance to immerse yourself in the case and become a real instant expert, and of course move on to become an instant expert on the next case. But I was starting to think that I was going to do 40 or 50 years of wrongful dismissal cases in Adelaide. And a man called John Mommis, who was then the Minister for Decentralisation in the Papua New Guinea government, was a close friend of my sister, who'd married a Bougainvillean in 1973. And John Mommis was brought on a DFAT, thank you Annie, visit to Australia and met me in Adelaide and suggested, I was a bright young lawyer, why didn't I come and work for his department of decentralisation? Now, that sounded interesting. Bougainville was an interesting place. So I thought I'd take a couple of years off from Adelaide. I rented out my house, and it took a bit of time to arrange, but eventually I came to Papua New Guinea and became the acting head of a little legal unit in the Department of Decentralisation. And unbeknownst to me, who'd hated constitutional law at the university, found it utterly boring because it was all about what the High Court said without ever questioning what the High Court was saying or why it might have said it or what its impacts might be. I remember we arranged for Lionel Murphy, new High Court judge, to come twice to the law school to meet with the students. We got 7 students one year and 8 students the next. There wasn't a great deal of interest in political economy. So there I was in Papua New Guinea, and I suddenly realised that we were implementing a constitutional settlement to a major constitutional crisis. In 1975, 2 weeks before Papua New Guinea became independent, Bougainville had declared unilaterally its independence from Papua New Guinea. the dispute was settled only about nearly a year later in an agreement which led to the first major amendment to the Papua New Guinea Constitution at the end of 1976, and an organic law, a constitutional law on provincial government enacted in 1977. So I was actually helping to implement a constitutional settlement. And suddenly, constitution making looked very interesting, and constitutional law. And about 6 months into my job, a man I'd never heard of, a little Indian man, sorry Basim, called Yashkai, came walking into the department. Now, I didn't know that Yashkai was a stellar constitutional lawyer. It turned out he'd advised the Papua New Guinea Constitutional Planning Committee on independence, constitution, and it helped them adopt things from East Africa, including an enforceable leadership code. And then, because he'd got to know John Momis as the chairman of that constitutional, or deputy chair, but de facto chair, he advised the Bougainvilleans in the making of the Bougainville Agreement, and he had these draft copies of the organic law, which he'd helped settle. And he wanted to look at our running file, because he wanted to catch up on what had happened in the implementation of the arrangements he'd helped develop. So we showed him the running file, and he started explaining a bit of the history, which I didn't know about. I thought, wow, this guy's interesting. So I suggested that he run a workshop for us, for all the provincial government lawyers and others working on provincial government matters. So he ran a 2-day workshop, and it was like a sort of road to Damascus moment, of blinding light. And it set me on the path to trying to see how constitutions and law could be used for all sorts of practical and in particular conflict resolution purposes. Now, I must say before I go on that I owe a huge debt of gratitude to both John Momis and to Yashkai, who've been friends and mentors throughout my life ever since. Yashkai was a referee in my last 2 promotion applications. John Momis was a referee. So they're both going to receive the video of this presentation, and I'll record here my lifelong thanks to both of them. So that's a sort of sidelight to the occasion. As I said, it's a daunting prospect doing a lecture like this for me, because I'm an accidental academic. I never thought I'd become an academic. I've never done any kind of postgraduate study of any kind, neither honours nor masters or PhD. And thank you for the ANU to being so open to recognising other things. I became an academic accidentally by being asked to write about the work I was doing in Papua New Guinea. And as I wrote more, and it was quite interesting, it got published. People found it interesting, I should say. I got asked to do more, and I ended up teaching at the University of Papua New Guinea, teaching constitutional law. And a Ugandan lawyer who was drafting most of the laws for provincial governments in Papua New Guinea was working in the Legislative Council's office. A tall, imperious-looking Ugandan called James Wapakawulo mentioned to me one day when I went to see him about a law he was drafting that he'd been an overseas representative for the last 5 years of the national resistance movement in Uganda. And the national resistance movement, led by his former roommate at the University of Dar es Salaam, a man called Yoweri Museveni, they'd won the guerrilla war. And Museveni was now president, and he wanted Wapakawulo to come home and be a minister. And he said, by the way, there's a number of things about the the Papua New Guinea constitution that I think would be useful for East Africa. for Uganda in particular, including this enforceable leadership code, which of course Papua New Guinea had adopted from East Africa, from Tanzania. And so 3 years later, Gareth Evans was touring Africa, went to Uganda, and Yoweri Museveni had some notes in front of him and said, we want this, he didn't say obscure Australian lawyer, but this Australian lawyer from Papua New Guinea to come and be an advisor. So that led to 3.5 years in Uganda, working on a post-conflict constitution. I went back to Papua New Guinea in 1994, and a few months after getting back, teaching at the university, I was asked to go to a peace conference in Bougainville as a possible rapporteur. And that's led to the next 30-odd years of heavy involvement in the Bougainville peace process. The Bougainville peace process and the work I did there has led to me getting involved in advising in Sri Lanka, where there was a lot of interest in the Bougainville solution as a way of helping the Tamils find a way ahead in their dealings with the Sinhalese-dominated government. And it led to involvement in advising the Naga people in northeast India. So there's a series of ongoing engagements that I've been involved in. I've said on the title that it's Insights from the Pacific in Asia, even though we're in the College of Asia and the Pacific, because my main experience has been in the Pacific. And the work I've done in Asia, in Nagaland and Sri Lanka, which is ongoing, has been because of what I'd learned in the Pacific. And I think there's a great deal to be learned from conflict resolution and constitution building in the Pacific, much more than is realised. They're small jurisdictions. They don't get noticed very much. There's a lot of other things about conflict resolution in the Pacific which are beyond discussing today, but one of the incredible things about the Bougainville peace process is the extent to which Bougainville culture drives the peace process. Because there's ingrained in Bougainville very small-scale societies a need to deal with conflict when it happens and resolve it. And then usually after conflict resolution, there's long and complex processes towards reconciliation, to restore relationships. So it's very hard to go back to conflict. It can happen, but it's very hard to go back to conflict when you've gone through these reconciliation processes. That's driving an amazing example of peace building and constitution making in Papua New Guinea. And it's possible to some extent in Papua New Guinea because there's strong resonances of that same culture in the rest of Papua New Guinea. How much does that apply in the rest of Melanesia? How much does it apply in Polynesia, in Micronesia? I suspect there's a lot to be learned by exploring that. We're not going to do that tonight, but it's another reason why I'm putting Pacific before Asia, although Pacific tends to be seen as a small sister or brother rather than the one that's most to be learnt from. Okay, constitution making and conflict resolution. I learned a lot from being a lawyer about immersion in becoming an instant expert. I found that I can't become an instant expert in the cases I'm dealing with in conflict resolution and constitution making because they're too steeped in history, in culture, in politics, in economics. So all I can do is immerse myself as much as I can. And I've been very lucky with Bougainville. I've been immersed in one way or another in Bougainville for 42 years. In Uganda, I got immersed because I spent over 3 years there with my family. 2 of my children were born there. Unfortunately, my wife can't be here, but I'll be sending her the video as well, so I'll be thanking her for supporting me to go and work in these unusual places and loving it, which is why she's now into her about 15-month living in Pari village in Papua New Guinea in the National Capital District, doing a deep sort of ethnographic dive into living in a village in urban Port Moresby. So we lived in Uganda and I became immersed. I now am working in other places like Fiji, Solomons, Vanuatu, Sri Lanka. I'm not able to immerse in the same way. I can't go and live there. But you can immerse to a high degree by really talking to people as much as possible, by reading everything you can, and by teaching. I'm teaching a course this semester on resource conflict in Asia and the Pacific. And we're doing a number of case studies. They're all case studies being presented by people with real knowledge of the particular places. And I'm doing the case studies on Bougainville, Sri Lanka and Nagaland. And by teaching about Sri Lanka and Nagaland and about Bougainville, there's a sense of immersion. I read huge amounts and really try and distill it down into something manageable for the second year students in a 90-minute lecture. It's a form of immersion. So immersion to me is, if I was to be giving advice to other engaged lawyers doing the same sort of work that I'm doing, immersion of various kinds would be very important. Constitution making and conflict resolution, they're not normally put together, but constitution making is only involved in some conflict resolution processes. And even when it is involved, it's of course usually only one of many factors involved and is not necessarily the key to resolution of any conflict. So I'm not suggesting that constitution making needs to be looked at as the key. It's merely one of many factors. At the same time though, choices of both the constitution making process and the constitutional contents agreed to in a process can contribute to conflict resolution and sustained conflict resolution. But no certainties in any of it. Constitution making in the right sort of situation, in a conflict resolution process, offers some real benefits, because for those who are trying to sort out a problem, particularly in intra-state conflicts, which is what I'm talking about here, not interstate conflicts, conflicts within countries, where you're dealing with dissident groups that have been very unhappy with the status quo and are challenging a national government. When the thing is settled, they want to know it's going to be settled long term and that the solutions agreed to are going to be in place and working long term. So constitutions offer some degree of certainty there. There's difficulties there because the dissident leaders often don't really understand what a constitution is or the possibilities that constitutions offer, and often they don't trust the constitution. Ezekiel will remember he was an advisor to the Bougainvillean groups that I was advising as well in the peace process in Bougainville from 1997-98 right through until the Bougainville Autonomous Government was established. Then he became a politician. He was a lawyer advising some groups, I was a lawyer advising other groups. It was like many intrastate conflicts, it was quite messy, multiple factions. And much of the difficulty was in the conflict between the factions, not just the conflict between some Bougainville factions and the Papua New Guinea government. That's common in the new so-called conflicts, intrastate conflicts. So often the dissidents don't trust the constitution. I don't think Ezekiel was present at a meeting we had with the BRA leaders in 1999 a few weeks before we finalised the Bougainville negotiating position. And one of what was called the hardline leaders, they were the political leaders who were supporting the BRA. This was David Sisito. And David, this is a meeting of about 30 or 40 BRA leaders in a fairly cramped conference room. And David, after we've been discussing and I've been explaining the ideas about autonomy and a deferred referendum and so on, and it would be in the Constitution. And David said, "You lawyer," he's saying this in talk visit, "You lawyer, why do you want to put us under the Constitution of Papua New Guinea? They fought us under that Constitution. They abused our human rights under that Constitution. How can we go under that Constitution?" And so we had to very gently explain how a Constitution works, and that the Constitution that applied up until this point, I remember drawing on a whiteboard, the Constitution up to this point had caused a lot of problems for you. But if we make the changes we're talking about, the Constitution will be changed to protect you, and the Papua New Guinea government won't be able to amend it without your agreement, because we'll be proposing what we term double entrenchment. You know how a normal constitution is entrenched in the sense that it's hard for the national government to change it. It's the fundamental law. What are we doing in Australia at the moment? What's double entrenchment? Well, we said you'd have to go through all the normal Papua New Guinea national government requirements for amendment, but in addition, it would require, for an amendment to anything in the Bougainville chapter of the Constitution, it would require the approval of the Bougainville legislature. So it would no longer be the Papua New Guinea Constitution, it would be also your Constitution, and you'd have unamendable rights under it. They could see that. And David Sisito agreed. There was a long discussion, many hours of discussion, and eventually the head of the BRA group, I think it was Ismail Tarama at the time, said, "Who's that he support him this on the talk? Suti mani go and tap." So who supports this? Put your hand up. And they all put their hands up. So it was a huge breakthrough. But that's an indication of some of the difficulties that are involved in using constitution making in conflict resolution. And in a way, this was one other point that we convinced them with, it depends on the record of constitutionalism in the country concerned. We were able to say to them, look, whatever you say about the Papua New Guinea Constitution, they generally adhere to the Constitution, particularly if the court tells them they have to. And we told them about what had happened to Pius Wingti, the Prime Minister, in the middle of 1994, when he tried to evade grace periods that protect a Prime Minister from motions of no confidence by resigning and then getting himself re-elected the next day. It went to the Supreme Court. The Supreme Court, Bernard Narakobi, who many of you would know, ran the case. The Supreme Court said this was unconstitutional. I won't go into the reasons for it. And Wingti accepted. And Chan then became the Prime Minister, and in fact that helped the peace process move along. But that's a different story. That's a different side of constitution making. So that helped, the record of constitutionalism. So if you try and persuade dissidents in another country where the record is very bad, I think they might, David Sisito might not get quite so easily convinced. Now, turning to process, because we're looking at both, remember I'm saying that constitution making can contribute in conflict resolution situations through both process and content. In relation to process, there's a lot of debate about how constitution-making processes should be run. And in the 1990s, a school of thought developed that public participation in constitution making was terribly important. Now, by the way, that was not something new to Papua New Guinea. Papua New Guinea probably really invented intense public consultation in constitution making through the Constitutional Planning Committee headed by John Momis, that I mentioned before, and advised by my mentor, Yash Guy. They had an incredibly consultative and participatory constitution-making process where they developed detailed guiding questions and explanatory papers. They set up discussion groups, official discussion groups, in every district and sub-district, what are now provincial provinces and districts. And that material was all fed back to the Constitutional Planning Committee and was taken into account. This is still a document I use constantly. It's the report, the 1974 report of the Papua New Guinea Constitutional Planning Committee. And they record in detail, this is what the people said on this, and this is the reason why we've chosen that. So they were really participatory. But in general, constitution making was not particularly participatory until the 1990s generally. Constitutions tended to be made by small groups, mainly of men. There was the odd woman who snuck in. Sitting in closed rooms with lots of lawyers, and working out what was right for the country. Now, it's interesting then that participatory constitution making is now the subject of quite a bit of criticism. One of the criticisms is that in the 1990s, when authoritarian regime constitutions started being overthrown and replaced by democratising constitutions, a claim was made by those supporting participatory processes that participatory processes would enhance democratisation because the people would know about their constitution and would be willing to support it. So, of course, the subject became an issue of deep academic research. Here's a book called The Participation Myth, because the researchers said, well, look, the hypothesis is participation leads to increased democratisation. They went and did studies. This book in particular did a study. It took 20 countries that had had participatory constitution-making processes and compared them with another group of countries that had had no participatory process and measured democratisation in the 10 years after the constitution had been enacted. And of course it turned out that many of the non-participatory ones had had democratisation increase as they measured it. There's a few questions about the research. And there were participatory ones where the democratisation had reduced. And even where there was participation, some increased and some reduced. An example, the introduction to this book gives, surprise, surprise, Zimbabwe's participatory process led to reduced democratisation followed it. Whereas Kenya's, highly participatory, democratisation increased. Now, I'm sure many of the social scientists here could point to some of the obvious flaws in this thinking, that there might have been the odd other factor involved. But that's now become a sort of almost a new orthodoxy. There was a new orthodoxy about participation being the right thing. There's a further new orthodoxy which says it's highly questionable. I'd argue that participation has, in general, a lot of benefits, and I won't go into them in any detail. But there's good evidence that it does help in all sorts of ways in socialising the whole idea of a constitution and then the kinds of solutions that a constitution after a conflict comes up with. It's not necessarily going to solve everything. But apart from, sorry, I haven't been running through this PowerPoint, have I? I'm sorry, I won't even bother. I don't know why I produced it. I'm sorry, Ale and Lee and Luca, the people who helped me get this together. I generally don't use PowerPoints. I like to tell a story. I hope you picked that up. Where was I? Quite apart from participation, there's and I shouldn't say quite apart, a very closely related issue is inclusion. And inclusion is a critically important thing, I think, in both conflict resolution and post-conflict constitution making. Inclusion leads to all sorts of things. By bringing to the table women's representatives who tend to get excluded from conflict resolution processes and generally in the past from constitution making processes. Remember the constitutions made in the closed rooms by the smoking men. There were very few women who ever got involved. Minorities can be brought in by representatives in inclusive processes. There's a whole possibility for getting new issues on the agenda through inclusion. So I'm suggesting that both participation and inclusion are very important. Intrastate conflicts, as I've said, tend to have multiple dissident parties and interest groups. They're often very divided, as I said, often opposing one another more than they do the central government. And so the inclusion of them is terribly important, as much as possible. Now, in many conflicts, we have interest groups, factions who refuse to join the dissident group that are negotiating with the national government. And that was a situation in Bougainville, where if you'd sort of divided the spectrum of Bougainville factions into left and right, it's a little bit like our referendum on The Voice. People on both the left and the right, for a period, refused to come in. Francis Ona, the head of the BRA, refused to join. John Momes, if you sort of put him on the right, refused to join. People from some of the groups that Ezekiel was looking after refused to come in. In many instances, they would be regarded as spoilers. Those of you who know conflict resolution literature around the world, there's a guy called Stedman who did a lot of work in Latin America, and he classified groups that wouldn't come in and oppose what was happening as spoilers. They were damaging the peace process. I'd say that's not necessarily the case in my experience. The groups that stay outside, their views have to be taken into account if there's going to be a working, lasting solution. Because if they're ignored, they're really going to fight it. So they have to be listened to and their views have to be put on the table. It also helps the more radical elements in the group that are negotiating with the national government, is as the BRA people were often able to say, and the other groups in the Bougainville process, they'd be saying to the national government, look, I know you think this is very radical, but if we don't have this in there, Francis Ona is going to build up his support and the peace process will be destroyed. So you've got to go with us. And it was quite a powerful argument. So inclusion can happen both directly and sort of indirectly. And I question the conflict resolution literature about the universal danger of spoilers. I haven't done a spoiler myth study yet because I don't have enough case studies. My pool of case studies is very small, and I'm certainly not suggesting I can draw any hard conclusions. These are, what I'm proposing really is advice to other engaged lawyers and advisors. In a multi-stage conflict resolution process, and many are really multi-stage, and in a multi-stage constitution-making process, which many are, there are many opportunities for inclusion and participation of different kinds. And if you're thinking about the advantages of it, you can be plugging those possibilities in. I've got some tables, which I probably should try and show you. My apologies for this. This is a participatory constitution-making meeting in Bougainville at Kuneka, down in Nogavisi. This is we were walking back from the Kuneka meeting through the bush, and somebody took photos. I was a little younger in 2003. I'll come to them in a minute. I've done a series of slides of the different conflicts and constitution-making processes that I've been involved in. I'm not going to go through them. I developed them over the weekend really just to help me distill some things out. So in each of the cases I've worked on, I've tried to look at the time, the key issue at the time, what was the real constitutional issue, what was their conflict issue, what was the constitutional initiative, was there public participation, was there success or failure? The Bougainville slide is from 1973 to the next slide, 2023. We're still going, multiple stages. And if you look at what happened in 1997 on to now, there's been multiple phases where participation and inclusion has been needed in different ways. And there's a very strong appetite for that in Bougainville. There's a huge problem with Bougainville meetings in that large numbers of people want to be on the plane going to Bougainville going to Port Moresby or Kokopo or Wabag for any meeting. There's a reason for it. There's a lot of people criticise it. They say it's all about staying in hotels and getting allowances. Well, there's an element of that. But the real thing that drives it is a need to be involved and a need to be able to report back to your group about what happened. So inclusion and participation happening at multiple stages is very important. So inclusion can extend not just to the parties, but to other interest groups, can occur in multiple bodies, and can achieve multiple purposes. Multiple voices, fairness, focus on gender, and so on. There's a range of issues to think about too, about how these different processes work in different situations. And what I'm saying here is that the nature of the conflict and how it's resolved can have a significant impact on the way a constitution-making process is undertaken. For example, if there's a definitive military victory in a country that's divided after a long and complex conflict, and it will remain divided even after the military victory, those in control of the new government are still under some threat. They know their hold on power is still a bit precarious, even though they might have the military strength. And that was the situation in Uganda after Museveni came to power and my friend Wapakawulo went to join his cabinet in 1986. So they worked on a constitution-making process with a view to trying to resolve the most contentious issues that were dividing Uganda. And they were many. Uganda is divided across multiple axes. The south traditional kingdoms. The north, small-scale societies, a bit like Papua New Guinea. The north mainly Protestant, the south mainly Catholic. You just go on and on and on. There's all these problems. So how are they going to get all these issues resolved? They decided to use the constitution-making process. And they set up a constitutional commission of 24 people with prominent people on it from all the main factions, and gave them the job of having a hugely public consultative process of making the constitution. They did a great job. They took about 2 years consulting, and by the end of it, there was clear consensus amongst the views coming from the people and on the commission, and as a result, on most issues. And by the way, that was a group who had put out a huge amount of material to help focus the constitution-making process. They had a guiding questions booklet of about 50 pages with 253 questions on 29 topics, mostly related, a lot of them related to these very divisive issues. At the end of all of that, there were still 10 highly contentious issues that the Commission, with all its different members, couldn't resolve. So they decided, right, we've had 27,000 plus written submissions, most of them responding in one way or another to some or most of the questions we asked. Let's analyse what they said in all these 27,000 plus written submissions. So they engaged 60 research staff. I helped coordinate the training and the operation of these staff. And they were trained to identify what was the closest option of the various options that there were on each contentious issue that the submission supported. And they did a statistical analysis. And it came out fairly clearly on each issue what the majority was, and they'd agreed in advance that they would adopt whatever the majority said. And they did that. And so the draft constitution that went to the National Constituent Assembly, which was elected in fair elections and of course was representative of all the different factions in Uganda, that draft constitution had huge legitimacy because of the way the contentious issues had been dealt with after massive, well-organised public consultation. This is the 400-page volume of the report of the Constitutional Commission containing a list of every single submission. Just gives you an idea. Now, I didn't bring the equivalent of the Papua New Guinea report, but the Uganda Commission came up with a similar report, a huge 500-page document. And again, it discussed how the people's views were presented. So these are all issues about process. Let's move on to content very quickly. Some key constitutional content issues. Length and detail. We had a number of American lawyers came and advised the Constitutional Commission in brief meetings in Uganda, and they all said you need a short constitution that deals with just the key issues in very simple terms. And the Ugandan Constitutional Commission was thinking more in terms of the Papua New Guinea Constitution or the Indian Constitution, these post-colonial constitutions that didn't follow the European or American model, that tried to deal with lots of the problems that had come up during colonialism. And we're finding in the post-authoritarian constitution making in the 90s and onwards, more and more constitutions are of a similar kind, long and detailed, as they try and take account of sources of conflicts and problems. So length and detail, don't worry about it. Self-determination, big issue in intra-state conflicts. There's two ways in which people talk about self-determination. The main focus of the international community, of course, is on internal self-determination. And international human rights law says there's a right to self-determination really only in two circumstances. One is decolonisation, where there's an absolute right, and the other is possibly in situations of absolutely gross violence and human rights abuses and so on. So they like internal self-determination, and there are ways. And you've got to be very careful of rejecting internal self-determination and going for a unilateral declaration of independence if you don't like internal, because then you can end up without membership of the UN and the international finance institutions and so on, and become like Somaliland or Kosovo. There are options for internal. Uganda's traditional kingdoms, very high levels of autonomy. Bougainville has a very high level of autonomy. It has its own constitution on its institutions and structures. It can't be suspended by the national government. Its powers can't be withdrawn by the national government. And its powers and functions and arrangements are protected by double entrenchment. Bougainville's agreement is required before any change to the national constitutional arrangements. There's federalism, there's the New Zealand model of free association. They're all different approaches to internal. There's a compromise on internal and external, which New Caledonia and Bougainville are the main exponents of. And by the way, Bougainville's model derives from the New Caledonia Noumea Agreement of 1998. That's leaving external self-determination to a later referendum, and in the meantime having a high level of autonomy. Then with external self-determination, there are some options too. You can have this deferred referendum, but you've got to be very careful whether the outcome's binding or non-binding. Bougainville's in a difficult situation at the moment. It had a referendum, 97.7% voted yes, but it wasn't binding. And there's a post-referendum decision-making process, but PNG believes that at the end of that process, it can vote in the parliament to say no. So what happens then? You can have an agreed binding referendum with the possibility of repeats. New Caledonia had 3 because of the fear that the Kanak population, which was less than 50%, would have no chance. So they needed 3. We looked at doing that in Bougainville, having 2 or 3, not because of the minority situation, but because we'd have trouble getting perhaps the 2/3 majority that would give legitimacy, because there were anti-independence people. So it was decided to ask for up to 3 referendums if there wasn't a vote of 66% in favour, because we wanted a clearly legitimate result. PNG was horrified at a referendum and even more horrified at 3. We dropped it. You can have agreed independence, perhaps deferred for a period. Or you can have external self-determination that leaves some powers with the parent state, as with the Micronesian approach, where because they have most powers, and in particular foreign affairs powers, Federated States of Micronesia, Marshalls and Palau are members of the UN, even though the US retains quite significant powers, mainly in relation to bases and the exclusion of forces from other countries, from the territory of those 3 countries. So that offers a possible model. There's a few others. Addressing grievances through things in the arrangements. Gender. Very little focus on gender in Pacific constitutions. The Bougainville Autonomy Constitution created 3 seats for women out of a house of 40. And those 3 seats reserved for women have now led to, at least in this House, 2 women in normal seats. And in addition, the Bougainville government has established a system of community governments in 2016 where the membership is gender equal. Every ward elects both a man and a female, and the chair has to be, if it's a male for one term, it has to be a female the next term. So, of course, in the first term, there were 44 males and 1 female. Second term, there's 44 women and 1 male. And that wouldn't happen, I don't think, although I haven't done careful of participation myths, that probably wouldn't have happened if the Constitution hadn't introduced the focus on gender. Implementation needs to be looked at because it's such a danger. And there are things. Oversight of the constitutional drafting. Incentives to implement. Bougainville had some of that. Oversight of constitutional implementation. Bougainville has a joint supervisory body. Kenya has a commission for the implementation of the 2010 Constitution. You can protect conflict resolving constitutional change from even the threat of unilateral amendment with double entrenchment. So, I'm finishing, Helen. Last slide. What are some possible lessons for an engaged lawyer? Remember, I'm not an academic, I'm an accidental academic, so these are the conclusions I draw. I haven't got into the real social science. Immersion is critical, and trust. You're advising on really sensitive issues. Remember what David Cicito said to me, you lawyer. The value of precedents, they're really important, but you've got to use them with great care, and you've got to introduce them with great care. And you've got to be willing to see that sometimes a precedent will deal with a symptom of a problem, but not necessarily a cause. And I can give you some examples of that, but Helen's warning me. Importance of being open to seeing both the intent and the possible utility of local options. You don't have to rely entirely on precedents. If you're listening, if you're immersed, if you've got trust, you can hear a lot of interesting local solutions, some of them driven by culture, as in Bougainville. The importance of the role of drafters of both peace agreements and constitutional provisions, and the traps. In Bougainville, in the peace agreement, it said the Papua New Guinea Parliament would have ratification powers, and in brackets it said final decision-making authority. But ratification normally, this is in relation to the results of the referendum, but ratification we normally understand as sort of just box ticking. But it said also final decision-making power. Well, when we went to the drafting of the amendments, we said, look, ratification is too confusing, we mustn't use that. For some reason or other, PNG didn't insist on putting in the words final decision-making authority. And we're now in this post-referendum constitution dispute resolution process about the referendum, arguing about this word ratification and why it was left out. And, the importance of participation and inclusion in multiple stages, multiple levels, and in terms of content issues, self-determination questions are always difficult to deal with, but as with most difficult issues, when options of the kinds that have been outlined are put on the negotiation table and considered seriously, it can be remarkable how much each side, where each side seeks to take account of the concerns of the other, that bespoke arrangements for the particular place emerge. Sorry, Helen. Thank you very much.